Can my employer force me to sign an unfair contract? Imagine this. You show up at work like any other day. You're doing your job, trying to support your family, just trying to keep things steady. Then the manager calls you into the office and hands you a document. Maybe it's called a new policy agreement, or updated employment contract, or company handbook acknowledgement. They say, sign this today, or you can't keep working here. There's no time to read it carefully, no room to negotiate, and no real explanation of what's inside. Maybe the contract says you can't sue the company. Maybe it says you can't talk about your wages. Maybe it says they can change your schedule whenever they want. Maybe it says you must pay the company if you quit. And you're thinking, can they really do this? Can they force me to sign something unfair? Today, we're going to break that down clearly. When we talk about workplace contracts, it's easy to feel powerless. Many workers think that if an employer hands them a contract, they have no choice but to sign it. But the truth is more complicated, and the law is not blind to power imbalances in the workplace. Employment contracts are governed by basic contract law, which requires certain conditions to make an agreement valid. For a contract to hold up legally, it must be voluntary, it must be clear, and it must be fair in how it was agreed to. If pressure, threats, or coercion are involved, the contract may not be enforceable, and no contract can take away rights protected by federal or state law, even if the document says otherwise. Let's start with something important. An employer cannot make you sign away your legal rights. That is a principle recognized by federal law, including the Fair Labor Standards Act, FLSA, which ensures minimum wage and overtime, Title VII of the Civil Rights Act, which prohibits discrimination, the National Labor Relations Act, NLRA, which protects your right to discuss wages and workplace conditions, and OSHA, regulations, which guarantee your right to a safe workplace. So, if a contract says something like, you agree not to discuss your pay with coworkers, or you agree not to report unsafe conditions, those parts of the contract are automatically invalid. The employer cannot override federal law simply by printing words on a piece of paper. But here's where the situation gets tricky. Employers often present these contracts in ways designed to create pressure. Maybe they say, this is just standard paperwork, or everyone signs this, or it's just company policy, nothing to worry about. Or worse, sign this or you'll lose your job. That pressure makes workers feel trapped. But under contract law, coercion matters. If you are forced to sign under an ultimatum, and especially if the contract takes away fundamental workplace protections, it may not be enforceable, even if you signed your name. Now let's talk about arbitration agreements. This is one of the most common things hidden inside workplace contracts. These clauses say that if a dispute happens, you can't take your employer to court. You must go through private arbitration. Arbitration can limit your ability to seek damages, join class actions, or make complaints public. It's one of the strongest tools employers use to protect themselves from accountability. Are arbitration agreements always enforceable? Not necessarily. Courts have overturned arbitration clauses when workers were misled, pressured, or not given a chance to review the terms. And the National Labor Relations Board, NLRB, has ruled that employers cannot use arbitration agreements to stop workers from discussing wages or organizing. Another common clause is the non-compete agreement. It may say that after you leave the job, you can't work for a competitor for 6, 12, or even 24 months. For many workers, retail, warehouse, restaurant, cleaning, delivery, these agreements are deeply unfair. They can trap workers in jobs with low pay by making it risky or impossible to find new work in the same field. The Federal Trade Commission, FTC, has proposed rules that would ban most non-compete agreements for workers because they harm competition and limit job mobility. Many states have already banned them for most workers, including California, North Dakota, Illinois, Minnesota, Oklahoma, and others. And even in states where non-competes are allowed, they are often not enforceable if they are too broad or clearly unfair. So, if your employer asks you to sign something that says you can't get another job in your line of work for a year, that clause may be invalid from the start, depending on your state. We also see contracts that try to take away the right to overtime. For example, the employer may say, "We pay a flat salary, no overtime." But under the FLSA, overtime is not something that can be waived or given up. If you are a non-exempt worker and you work over 40 hours in a week, you must be paid overtime, regardless of what any contract says. Even if you signed it, even if your employer insists the agreement is binding, the law is the law. Now, let's talk about fear, because employers rely on it. A lot of workers worry that refusing to sign will lead to getting fired. And yes, most workers in the U.S. are employed under at-will employment, which means the employer can terminate employment for almost any reason, as long as it's not illegal. But if an employer threatens to fire you specifically because you are questioning something like wage rights, safety concerns, discrimination, or legal compliance, then that threat may be retaliation. Retaliation for asserting your rights is illegal under federal law, and contracts signed under threat of retaliation can be challenged. There's also the issue of not having time to review. If an employer demands that you sign something immediately, without time to read, ask questions, or seek legal advice, that is a sign of procedural unfairness, which is something courts look at when deciding whether a contract is enforceable. You have the right to say, "I need time to review this. I'd like to take this home to read. I want to ask questions before signing." If the employer says, "No, sign it now or leave," that pressure is important evidence. It suggests the contract is being used as a tool of control, not an agreement between two informed parties. We've also seen employers use contracts to shift business costs to workers, things like uniforms, equipment, training fees, or early termination fees. Under wage and hour laws, employers generally cannot deduct costs that bring your pay below minimum wage, and they cannot require you to pay to work. So even if the contract says you agree to these deductions, they may still be illegal. When workers challenge unfair contracts, they often win. Not because of magic, but because the law recognizes that employers hold more power than workers and cannot abuse that power to strip away legal rights. The reality is that no contract exists in a vacuum. It exists inside the larger structure of federal labor law, state law, and basic contract fairness standards. And those protections are there to prevent employers from using paperwork to control, silence, or exploit workers. So, can your employer force you to sign an unfair contract? The answer is no, not legally. You may feel pressured, cornered, or afraid to refuse. But a contract is only enforceable if it is voluntary, fair, and consistent with federal and state labor law. Employers cannot make you sign away your right to minimum wage, overtime, safety protections, or the right to discuss your pay. They cannot take away basic legal protections by printing words on paper. If you're presented with a contract that feels wrong, ask questions. Request time to review. And remember, your signature does not erase your rights. If this video helped clarify the issue, share it, because knowledge changes power.